Fraud or willful misrepresentation. In this video, we are going to explain the differences, between those two charges or allegations, and really tell you how you can go about it if you do not have a waiver, if a waiver is not warranted under your circumstances and you do not have a qualifying relative for the purpose of applying for a waiver. My name is Bijoux Ngwanda, as you know it. I'm an immigration lawyer based here in DC. However, I do have clients across the country and around the world because we are dealing with complex U.S. immigration law cases. If you're new to my channel, please go ahead and subscribe. If you are not new, welcome back. Thank you for subscribing. And please do not forget to hit the notification bell so you don't miss out on anything. If you enjoy the content, you go ahead and share, like. Don't forget to comment below. Also follow us on all platforms. Links are in the description box below. Let's get right into it. Fraud or willful misrepresentation. Not or, but and. Sorry. Willful misrepresentation. But just know that if you are charged for fraud under immigration law, you are directly charged for willful misrepresentation, because all the elements of willful misrepresentation are included under the fraud charge. That's why if they say fraud, just know that willful misrepresentation is there too. So when is it that USCIS will say that you have been charged, or the alleged facts or the alleged charges are willful misrepresentations? So basically it has to be because you are seeking a benefit, under immigration law. You sought a benefit, or you are seeking a benefit under immigration law, and you made a false statement or a false representation, right? And that false representation was willfully made, and it was material, and you made it to a U.S. immigration officer, consulate, or judge, right? For the purpose, of course, of obtaining any immigration benefit under the U.S. immigration law. That's why they call it willful misrepresentation, But hear me out now. So if you have been charged for willful misrepresentation, or there's some alleged facts as far as willful misrepresentation is concerned, you have the possibility to waive it, right? Provided that you have a qualifying relative. Has to be a parent, a spouse, or a fiance, right? So if it's a spouse, it has to be a U.S. citizen, spouse, or lawful permanent resident. Fiance, we already know it's only U.S. citizen. And if it's a parent, it has to be lawful permanent resident parent or U.S. citizen parent. If you do not have those qualifying relatives for the purpose of applying for a waiver under willful misrepresentation, you're stuck, right? But exactly what can you do? You can try to argue that the willful misrepresentation in question was not material, because we've tried to argue that in the past. It has worked for certain applicants, it hasn't worked for certain applicants. Why? It just depends on the evidence that you have at hand to really show that the misrepresentation in question was not material. Material meaning what? Meaning that the misrepresentation did not have the tendency to influence the decision of the U.S. consulate, immigration officer, or anybody else. And it didn't shut down the line of questioning. And there's a way to explain it under immigration law. That's what you can do. If you don't have it, at least you try to argue, right? But when it comes to fraud, beside everything that we just cited, then they have to show too the intention to deceive. intention to deceive the immigration officer, consulate immigration judge, and the person in question believed you, right? You intend to deceive and they believed you. However, if you do not have those qualifying relatives, of course, you can try to argue that you did not have the intention to deceive. Intent, lack of intent, those are the type of argument we actually put out there. But remember that if you charge with fraud, willful misrepresentation is included. So you can defend the intention. However, how are you going to defeat willful misrepresentation? Then you have to show it wasn't material. Okay? So that's how you can pretty much try to argue a case if you cannot afford to do it under the waiver because you do not have a qualifying relatives, or the waiver argument is not really big for you because there's no extreme hardship to prove. You know, you can have a qualifying relative, it's one thing, but proving extreme hardship to that qualifying relative, it's another. So we can help you because we have helped some people before, or we can help you in terms of guiding you. We can help you in terms of defending you. We can help you in terms of applying for a waiver. We can help you in terms of just guidance, okay? If you need a consultation with me, my friend, you can schedule it by using the consultation link in the description box below. Until next time, bye-bye.